Well, I'll get started with my presentation. On Tuesday of last week in the House of Commons, parliamentarians convened an emergency debate about the chronic and deplorable conditions at the Attawapiskat Reserve in Northern Ontario. During that debate, Canada's Justice Minister, Jody Wilson-Raybould, provided a signal about how our new federal government intends to address one of the most intractable issues confronting policymakers in Canada. And that issue is reconciling the prior occupation of North America by Aboriginal peoples with the assertion of Crown sovereignty over Canadian territory. In other words, the coexistence of Aboriginal communities within the broader Canadian society. Prime Minister Trudeau has already made clear that his government considers the constitutionally guaranteed rights of Aboriginal peoples a sacred obligation and not an inconvenience. His mandate letter to the Minister of Aboriginal Affairs sets out an ambitious set of 13 priorities to address Aboriginal issues, including Aboriginal education, the inquiry into murdered and missing Aboriginal women, and a review of how Canada conducts its obligation to consult and accommodate Aboriginal communities. Ms. Raybould Wilson's remarks in the House of Commons last week provide further substance to the government's promise to change the Crown's relations with Aboriginal communities. She said that Canada intends to work with Indigenous peoples to establish a phrase that I'm sure many of you have heard, a nation-to-nation relationship that is based on recognition. She indicated in her remarks that the Indian Act is not compatible with the constitutionally protected rights of Aboriginal peoples, and that it's going to be replaced with a national reconciliation framework that incorporates the principles of the United Nations Declaration on the Rights of Indigenous Peoples. What I intend to do this afternoon is to review the government's proposed national reconciliation framework, and specifically I'm going to address the government's focus on the UN Declaration. I'm going to say this: I'm generally supportive of the approach by our new Prime Minister and his government, but I have grave concerns about the government's emphasis on the UN Declaration. I thought as a second topic that I would relate, it'd be useful to relate government policy to what is actually happening on the ground. I have since the mid-1980s done a lot of work in Prince Rupert, and I'm going to discuss how the process of reconciliation has affected the Simpson First Nations communities in the Prince Rupert Terrace area on the north coast of British Columbia. And then in my concluding comments, I hope to tie together those two issues. So let's start with the UN Declaration. The UN Declaration is not a new policy initiative for the Government of Canada. The Declaration was adopted by the United Nations nearly a decade ago with the objective of imposing international standards for the treatment of the world's 370 million Aboriginal peoples. The Declaration establishes individual and collective rights and is designed to protect Indigenous institutions, cultures, and traditions, and to promote the full and effective participation of Aboriginals in all matters relating to economic and social development. In 2007, the Government of Canada, along with the United States, Australia, and New Zealand, voted against the Declaration. 11 countries abstained from that vote. Canada's position at the time was that while the government supported the spirit of the Declaration, its provisions were incompatible with the protection of Aboriginal and treaty rights in the Canadian Constitution. That decision by Canada to vote against the Declaration was condemned internally and externally. That criticism, however, overlooked the fact that Canada is at the forefront of the international community in terms of recognizing and protecting the rights of Aboriginal peoples. In 1982, Canada enacted Section 35 of the Canadian Constitution. And this isn't going to be a legal seminar, but I thought it would be useful to show you Section 35 of the Constitution. That provision expressly recognizes and protects Aboriginal and treaty rights. I think it's important to note that Section 35 recognizes existing Aboriginal rights. This provision of our Constitution doesn't create new rights. I mentioned the criticism against Canada for voting against the UN Declaration. That vote was in 2007. 3 years later, Canada officially endorsed the Declaration, describing it as an aspirational document and making the point that the UN Declaration is not legally binding and does not change Canadian law. So there was a change in the way that the government perceived the UN Declaration. Now, since 2010, when Canada officially endorsed the Declaration, several courts across Canada have made clear that the UN Declaration can't be used to displace Canadian jurisdiction or laws about, for instance, the Crown's duty to consult First Nations, including whether the duty is owed and the content of that duty. So what the courts have done is that they have agreed with the Government of Canada that the Declaration is, in effect, an aspirational document that's non-legally binding and doesn't change Canadian law. All of that, however, may be changing. In recent months, both the Government of Canada and the Government of Alberta have announced their respective intentions to implement the UN Declaration. These initiatives appear to have been provoked by recommendations made by the Truth and Reconciliation Commission, which reviewed the deplorable history of residential schools in Canada. In its interim report, the Commission recommended that the UN Declaration provide a framework for reconciliation at all levels and across all sectors of Canadian society. In its final report, the Commission observed that the Declaration provides the necessary principles, norms, and standards for reconciliation to flourish in Canada. The Commission acknowledged in its report that the Government of Canada had already endorsed the Declaration. Now, both Canada and Alberta have indicated their intentions to implement the Declaration, and you won't be surprised to learn that as a lawyer, the word implement, in my view, means something much more significant than endorse. It signals an intention to fulfill or put into effect the UN Declaration, which, in my view, is undeniably different than the commitment that's been made to date. However, neither Canada nor Alberta has indicated specifically how their commitments will be affected in practice, or the extent to which the UN Declaration is intended to create new or different legal rights and obligations in Canada. And that's an important point because implementing the Declaration is perceived by many within the Aboriginal communities as more than a symbolic commitment. And rather than creating greater certainty in Crown Aboriginal relations, the initiative may very well set back the process of reconciliation, particularly in regards to Aboriginal land claims. I'm going to deal with two specific provisions of the UN Declaration. And the first is Article 26, which establishes Aboriginal ownership of land. The second provision of the UN Declaration dealing with land is Article 32, which sets out a requirement for the Crown to obtain the free, prior, and informed consent of Aboriginal groups for any projects involving claimed Aboriginal territory. I'm going to pause here for a moment to say that I read with interest the green paper that was prepared for this conference, and which I understand was presented this morning. The authors of the green paper trace the evolutionary relationship of people and the land, and that, of course, is the single greatest source of conflict between Aboriginal peoples and governments. Unresolved questions about land ownership, land use, and the extent to which First Nations can determine or influence and benefit from developments on land that is claimed as the traditional territories of Aboriginal groups is, in my view, one of the single most important policy issues facing governments. The issue, in my view, isn't whether Canadian law provides the necessary protection of Aboriginal rights. I believe it does. Rather, the problem and the conflict has been the way that governments, and in some instances, Aboriginal groups, have interpreted Aboriginal rights, and that's where we have conflict. Now, as I indicated already, the announcement by Canada and Alberta of their intentions to implement the declaration has raised expectations within the Aboriginal community. To illustrate, the First Nations Summit, which is a BC Aboriginal group that purports to represent the interests of Aboriginal communities in the modern treaty process, castigated BC Hydro for its position in a recent judicial proceeding involving the proposed Site C hydroelectric project in northeastern British Columbia. In that case, BC Hydro described the UN Declaration as an aspirational and non-legally binding document. According to the First Nations Summit, BC Hydro's position represents a fallback to the old colonial Crown policies of denying the human rights of Indigenous peoples. And I find that an astonishing statement. In my opinion, it's wrong for anyone to advance the argument that Canadian law does not adequately protect Aboriginal rights. Over the past 3 decades, Canadian courts have provided substance to the meaning of Section 35 and have, in a series of decisions, articulated criteria for establishing unextinguished Aboriginal rights, including Aboriginal title. Nevertheless, many Aboriginal representatives advocate that governments must obtain the free, prior, and informed consent of First Nations whose interests may be affected by decisions affecting their traditional territories. They interpret the UN Declaration as providing a veto over Crown decision-making. I'm not sure that that view is shared by the governments of Canada and Alberta, but the point I'm trying to make is that the emphasis both have placed on implementing the UN Declaration has created expectations and caused unnecessary and uncertainty in an area that is already fraught with conflict. Since 2004, Canadian law has imposed an obligation on the Crown to consult and, where appropriate, accommodate First Nations communities where Crown action may infringe the exercise of Aboriginal rights. Judicial decisions have crafted a careful balance between the rights of Aboriginal groups with the rights of Canadian society as a whole. I have on the slide set out a summary of what the Supreme Court of Canada has consistently set out in a series of decisions interpreting Section 35. The provisions of the UN Declaration, particularly those that deal with Aboriginal groups' interest in land, do not appear to engage the same balancing of interests that have been articulated in judicial decisions. Nor does the UN Declaration, and again, this is an important point, give any consideration to the strength of an Aboriginal group's claim. The UN Declaration doesn't deal with the impact of the proposed Crown activity on the exercise of Aboriginal rights, nor does it deal with the one issue that seems to be paralyzing the advancement of Aboriginal interests in British Columbia, and that is the specter of overlapping claims by several Aboriginal groups to the same area of land. Now, there are legitimate concerns whether the UN Declaration, if implemented, is consistent with the established body of law in Canada, and I'm going to come back to that point in a moment, but I want to move now from the theoretical to the practical. As I indicated at the outset, I've been involved in transportation and infrastructure developments in Prince Rupert since the mid-1980s. Today, Prince Rupert is anticipating unprecedented economic development as major multinational companies plan the construction of natural gas pipelines and LNG facilities for the liquefaction and export of natural gas from the north coast of British Columbia. Prince Rupert is situated at the southern tip of the Alaskan Panhandle, approximately 770 miles north of Vancouver. The city was built in the first years of the 20th century as the western terminus for the Grand Trunk Pacific Railway. Prince Rupert has never achieved the potential envisioned by Charles Hayes, who was the president of the Grand Trunk Railway and its major promoter. Hayes believed correctly that a railhead in Prince Rupert would provide a shorter route for transshipments to destinations in Asia. Hayes, however, and this is, if any of you have been to Prince Rupert, you'll know this is a story that many Prince Rupert residents tell. Hayes perished aboard the Titanic, and his dream for Prince Rupert has languished for more than a century. After his death, the Grand Trunk Pacific Railway slipped into bankruptcy, and the rail line was eventually absorbed by Canadian National Railways in the last century. But since the early 1900s, Prince Rupert has been exposed to the boom and bust cycle of a resource economy. And bringing this back to Aboriginal rights, the city lies within the traditional territory of the Simpson First Nation. And there are three features of Simpson history that are relevant to contemporary economic development. The first is that prior to and at the time of European contact, the Simpson were active participants in an entrepreneurial trading economy. However, the Simpson bands were marginalized as Prince Rupert developed in the last century, and that resulted in high rates of unemployment, poor educational outcomes, and poverty. And those were features of Simpson communities for several decades. More fundamentally, developments in the Prince Rupert area, including within the Port of Prince Rupert, were undertaken with little regard for Simpson culture and interests. The Fairview Terminal was developed by the Government of Canada, by the National Harbours Board in the late 1970s, and resulted in Simpson graveyards being unearthed and without any consultation with Simpson communities. Now, secondly, again, going back to how Simpson history is relevant to contemporary economic development, Simpson society was highly structured with rank and social standing, partly determined by tradition and inheritance. When the Government of Canada set aside reserves and established Indian Act bands, that resulted in reinforcing distinctions between Simpson communities, notwithstanding the fact that they share customs, traditions, and historical experiences. The result of that is that today, each Indian Act band, each Simpson Indian Act band, has an elected chief and council, but many of those bands continue to be governed by a hereditary leadership. My third point is that one of the features of Simpson life before contact with non-Aboriginal peoples was what scholars describe as the seasonal round, and that was a structured schedule of activities based on the harvesting of fish and other resources. The Simpson were somewhat of a nomadic people occupying winter villages in Prince Rupert Harbor, as well as territories on the Skeena tributaries and coastal islands. So in the context of contemporary legal principles, each of the 5 Simpson Indian Act bands can demonstrate unextinguished Aboriginal rights to Prince Rupert Harbor, although the relative strength of those claims varies from band to band. So what does this mean? Today, the Simpson communities are in the path of multiple projects, from oil pipelines to LNG terminals, and the Crown is required to consult and accommodate each of those communities about those developments. Those communities, however, have been challenged in their capacity to keep up, and resistance, if not opposition, has often been the inevitable response to those projects. Secondly, in some Simpson communities, it is the hereditary leaders and not the elected chief and council who have dictated community support or opposition for developments. And thirdly, the conflict between the Simpson Indian Act bands about their relative strength of claims to this one specific area in Prince Rupert Harbor has threatened to derail developments and has resulted, unfortunately, in litigation between the bands. Now, despite those problems, there's been a remarkable transformation in less than a decade. In 2005, the Prince Rupert Port Authority announced its intention to construct a container terminal facility. Initial efforts to consult the Simpson were ill-conceived and resulted in multiple civil proceedings against the port and the Government of Canada. Moreover, the divisions between the Simpson communities became intractable, with 4 of 5 claiming Aboriginal title to the Port of Prince Rupert. Those issues, I was involved as a negotiator for the Government of Canada, and I can remember telling my client when I was retained that I thought it would be feasible to negotiate a settlement in the space of a few months. Well, 4 years later, we were still negotiating, but over time, those issues were addressed, and ultimately all 5 Simpson communities entered into impact and benefit agreements to facilitate the construction of the container terminal. And it's fair to say that since then, since the agreements were concluded in 2010, the capacity of those communities has improved significantly, such that those communities are now active participants in the local economy. And although not perfect, the relationships between the Crown, project proponents, and the Simpson are a positive example of reconciliation. Progress, of course, is always incremental when it comes to Crown-Aboriginal relations. And today, Pacific Northwest LNG is proposing to construct a natural gas liquefaction and export terminal on an island within the Port of Prince Rupert called Lilo Island. So this is just a few miles south of the container terminal. If this project proceeds, natural gas will be transported from the North Montney region of British Columbia to a facility on Lilo Island where it would be liquefied and then exported to customers in Asia. Construction of this facility would mark the largest private sector investment in Canadian history. So the Crown, both Canada and the province of British Columbia, as well as a project proponent, have been actively engaged with the 5 Simpson communities over the course of the past 4 years. And as of today, 4 of the 5 communities have entered into either term sheets or final agreements with the project proponent. One community, the Lax Kw'alaams, who have the strongest claim to unextinguished Aboriginal rights in the area, took the position up until recent months that they would oppose this project. However, a new chief and council were elected in the fall, and in the last month, that chief and council have indicated in a letter to the Government of Canada their conditional support for this project. However, there remains opposition within the community to the PNW project, and a man named Donald Wesley, who describes himself as the hereditary leader of the tribe that claims Lilu Island as its traditional territory is steadfastly opposed to the project and has set up a protest camp on the island. That's Mr. Leslie, second from left in that photograph. And that brings me back now to the UN Declaration, and specifically Articles 18 and 19, which, if implemented as part of Canadian law, will, in my view, cause compounded confusion and uncertainty and create an insurmountable obstacle to project development. Article 18, which is on the screen, would facilitate governance by hereditary leaders. And if implemented, this article would, in my view, lead to uncertainty about the jurisdiction and power of the elected chiefs and council to make decisions affecting community interests. Article 19 reiterates the principle of free, prior, and informed consent, and that is the article that has led some First Nations representatives to claim a veto right over developments on claimed Aboriginal land. So, how is consent to be obtained? That's a complex and difficult question. Who has the capacity to provide consent? Is it the Indian Act Band and Council? Now, the Indian Act geographically restricts the capacity of the Indian Act Band and Council to Indian Act reserves, and the jurisdiction of the Chief and Council is arguably restricted to the matters set out in the Indian Act. Is it the hereditary leaders who have the ability to signal whether or not a community will approve or oppose a project? And I'd ask this question: how many of you would be comfortable with a hereditary leader in your community claiming to have the jurisdiction to make decisions on behalf of the entire community? Or is it a tribal council, and there's an entity called the Simpson Tribal Council that, or other representative organization, that is the entity that ought to be able to provide consent. And when you have 5 Indian Act bands who all can claim some degree of unextinguished Aboriginal rights to the same area, should the government really be looking to an entity like a tribal council to provide that level of consent? That leads to the second question: what form of consent is appropriate? Is it a band council resolution from the chief and council? Is it a declaration from the governing entity? Or is it a community vote? And I mentioned the opposition of the Lax Kw'alaams Band to the PNW project a few moments ago. Last year, the elected chief and council of the Lax Kw'alaams Band convened community meetings in Fort Simpson, Prince Rupert, and Vancouver, where they invited community members to attend a presentation about the project, and then the participants were asked with a show of hands to indicate whether or not they supported or opposed the project. And you can imagine the difficulties associated with polling a community's support for a project or opposition by a show of hands. There was an overwhelming, through a show of hands, opposition to the project, which led the media to perpetuate the belief that the community is steadfastly opposed to the project. So, is it a community referendum? If so, is it a secret ballot? And if it is a community referendum, to what extent are members of the band who live off reserve entitled to participate in that kind of vote? Those are the sorts of questions that I think are logically raised when we look at the UN Declaration. And the third point is consent required of every Aboriginal group whose rights are or may be affected by a Crown decision. So today, you have 4 of the 5 Simpson bands saying we support the project. The one band that has the strongest strength of claim, if it reverts to its position that it's opposed, what's the Crown to make of that? Is consent required of every band that may have unextinguished Aboriginal rights in the area? So, My concluding remarks. Ms. Wilson-Raybould acknowledged the obvious when she spoke in the House of Commons last week. She indicated that change will not be easy and there are no quick fixes. And there's no doubt anyone who's involved in the area of Aboriginal and treaty rights would agree with that statement. She made the point that only the colonized can decolonize themselves. So she, and she's a First Nations person, she's indicated that it's up to First Nations peoples to figure out how they are going to become part, or they're going to coexist within larger Canadian society. She recognized that this is a long-term ambition, indicating that the national reconciliation framework that her government is advocating needs to survive the life of one government. And again, I agree with that. Now, the points I'm going to make in response is that recent history in Prince Rupert provides a ready-made example of the integration of First Nations communities in their local economies. There's been a substantive increase in community capacity in less than a decade. The communities are participating through the employment of their members and also through joint ventures that they've formed with companies that are actively involved in projects in the Port of Prince Rupert. And perhaps most importantly, the elected chiefs and council are involved in decision-making with respect to proposed projects in their areas. Success, however, is best measured incrementally. Opposition to the PNW LNG project within the Lac Coulombe community demonstrates how tenuous the principle of reconciliation is in practice. Now, the Government of Canada has lagged behind other governments in this country in addressing Aboriginal issues. That's changing. I think the emphasis by the Prime Minister in Aboriginal issues is a positive development, and I'm going to offer some gratuitous advice. The first is that the government should not let national and regional Aboriginal organizations dictate government policy. Rather, it's my view that the government ought to focus attention on Aboriginal communities, not the AFN or other organizations, and in doing so, recognize and address the diversity in those communities. And for communities in the path of projects, the best role of governments, in my view, is to provide assistance, to develop capacity, and to address the legitimate concerns that come out of the environmental assessment review of projects. It's naive, in my view, to believe that the interests of every Aboriginal group can be addressed, and governments have to be prepared in the balancing of interests to make difficult decisions. Thank you.